Is getting high beforehand the ultimate get-out-of-jail-free card? On May the 13th, there were a couple of cases that came out of the Supreme Court of Canada that resulted in a number of headlines that might make you think so. Today on Don't Talk TV, I'm going to take a look at those decisions and the law surrounding self-induced intoxication. Hello, my name is Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. On Friday, May the 13th, 2022, the Supreme Court of Canada released two decisions. The one was Her Majesty the Queen in Brown. The other case was Her Majesty the Queen in Sullivan and Her Majesty the Queen in Chan. The second two were heard together in one case. They were both on appeal from the Ontario Court of Appeal. So I had a number of people send to me links to articles suggesting that these decisions had basically given carte blanche to anyone to just get drunk or get really high and then go out and commit a crime, and you won't be held to account because the Supreme Court has now said self-induced intoxication is fine. That's not exactly what happened in these decisions. Both decisions, Brown and Sullivan, looked at Section 33.1 of the Criminal Code of Canada, and very specifically they looked at the wording of that section, and yes, that section was struck down as unconstitutional, but it wasn't quite the way it's been portrayed in the media. So I want to take a look at those actual cases. So starting with the decision of Her Majesty the Queen in Brown, as indicated, the citation is 2022 SCC 18. I'll put the link in the show description as always. I'm just going to scroll down here to the overview given by Justice Kazirer. As the section says, an overview, and I think it does describe the case. So, the case of Mr. Brown was circumstances were following a party at which he'd consumed alcohol and magic mushrooms. Matthew Winston Brown violently attacked Janet Hamnet, a person he didn't know and who had done nothing to invite the assault. The trial judge described him as being in a substance intoxication delirium that was so extreme as to be akin to automatism. So automatism is when you're basically don't have control over what you're doing. You're on autopilot, as it were, the automatism. You're just moving around without actually thinking of what you're doing, almost as if you're under the control of someone else. So as it says here, while capable of physical movement, he was in a delusional state and had no willed control over his actions. So he didn't intentionally do anything because he couldn't form intentions. Mr. Brown's extreme intoxication akin to automatism was brought about by his voluntary ingestion of the magic mushrooms, which contained a drug called psilocybin. So the court goes on again to describe what is automatism. So it's, quote, a state of impaired consciousness rather than unconsciousness in which an individual, although capable of action, has no voluntary control over that action. So examples given often include the involuntary physical movement of an individual who has suffered a heart attack or a seizure. So when one falls to the ground having a seizure, they don't intend to do that. They have no control over their body, but they're still moving around. So that's the level of lack of control that we're talking about here. Now, the court stressed at paragraph 4, these are not drunkenness cases. The accused in each of these appeals consumed drugs which, they argued, taken alone or in combination with alcohol, provoked psychotic, delusional, and involuntary conduct, which are reactions not generally associated with drunkenness. So getting blasted on whiskey or vodka isn't the same thing as having these very psychoactive hallucinogenic drugs that rob an individual of the ability to make a decision about what they're doing. So the court then talks about 33.1, said it was in response to the case of Her Majesty the Queen in Davio, and what the court ruled in that case was that it would be unfair to hold an individual responsible for crimes committed while in a state of automatism, as they're incapable of voluntarily committing a guilty act or having a guilty mind. So the Parliament came up with a law saying that, okay, but you can't use that defense if it was voluntary intoxication, whereas you purposely took the drugs, as opposed to a situation where, say, someone slips something in your drink, you don't know that it's there, and then you have the psychotic reaction as a result of nothing that you chose to do. We're starting to get to the key here in paragraph 8, where they say that Section 33.1 treats extreme voluntary intoxication foreseeable or otherwise as a condition of liability for the underlying violent offense and not as a measure of fault based on criminal negligence. So this is the problem that the Supreme Court has, is that Section 33.1 is essentially too broad. It just makes it a crime in all circumstances. So the court says that in a case like Mr. Brown's, he's not being held to account for their conduct undertaken as free agents, including the choice to ingest an intoxicant, undertaken when neither the risk of automatism nor the risk of harm was necessarily foreseeable. Instead, the accused is called to answer for the general intent crime they cannot voluntarily or willfully commit, an offense for which the whole weight of the criminal law in Section 711D say they may be morally innocent. The court says that, I hasten to say, there may have been other paths for Parliament to achieve its legitimate aims connected to combating extreme intoxicated violence. So they're not saying that it's impossible for the court to, or for Parliament to pass a law to make it, to take away certain defenses where voluntary intoxication, but they're saying the way it's worded right now is too broad. And as they say later on in the paragraph, it was not impermissible for Parliament to enact legislation seeking to hold an extremely intoxicated person accountable for a violent crime when they chose to create the risk of harm by ingesting intoxicants. So what the Supreme Court is saying is that an acceptable way of writing Section 33.1 would have been if there was some reasonable foreseeability that getting intoxicated might result in the becoming automaton. So what they're saying is that a law would be completely legitimate where if one got totally high in a premeditated fashion, thinking they want to commit a crime and this is a get out of jail free card, I'm going to get totally blasted out of my mind on magic mushrooms and then go do it. If they'd worded the law to deal with a situation like that where it was pre-planned or where it was foreseeable that you might become an automaton, then there would be that moral blameworthiness there because the person is either being reckless or negligent or purposeful when they get themselves intoxicated, versus a situation where one has no concept that this could be the result when they get intoxicated and then these things happen. Now, it's an axiom in law that bad facts make bad case law, and I think that is part of what happened here. Because let's look at some of the facts. I think especially Sullivan and Chan. Here's the background for Mr. Sullivan. It says, all parties agree that Mr. Sullivan attacked his mother during an episode of drug-induced psychosis during which he had no voluntary control over his actions. So he lived with his mother. He had a history of mental illness and substance abuse. Evidence at trial indicated that in the 3 months leading up to the attack, he was convinced that the planet would be invaded by aliens that were already present in his condominium. He had been prescribed bupropion under the name of Wellbutrin to help him quit smoking. Apparently psychosis is a side effect of the drug. He'd experienced psychosis from Wellbutrin at least once before. Shortly before the events of the case, the evening prior to the attack, he ingested 30 to 40 Wellbutrin in an attempt to commit suicide. So then he has this psychotic episode. He wakes his mother to tell her that an alien was in the living room. She followed him to the living room area, and while she was there, he went to the kitchen, took 2 knives, and stabbed his mother 6 times. There seems to be some suggestion that he thought she was one of these aliens. I think this is an example of like how out of control we're talking about, and again, not something foreseeable. The guy didn't take the drugs so that he'd think aliens were invading and kill his mother and get away with it. He took drugs trying to kill himself. Then if we look at Mr. Chan, he violently attacked his father. It says after returning home from a bar where they'd consumed several alcoholic drinks earlier that evening, Mr. Chan and his friends decided to take magic mushrooms. Now I think this is important. Mr. Chan had consumed mushrooms before and enjoyed the experience, so he's not expecting to become an automaton and lose control over his functions. And he certainly had no plan or intent to kill his father, as we'll see. So he ingested an initial dose. When he failed to feel the same effects as his friends, he took a second dose. Towards the end of the night, he began acting erratically. Frightened, he went upstairs where he woke up his mother's boyfriend, and sister. Mr. Chan then left the home wearing only a pair of pants. Family and friends pursued him. He ran towards his father's home a short distance away, broke into his father's house through a window, even though he normally would have entered through a fingerprint recognition on a home security system. And then once inside, he confronted his father in the kitchen, didn't appear to recognize him, shouted that he was God and that his father was Satan, and then he stabbed his father repeatedly, and Mr. Chan unfortunately killed his father. So I think these facts show you the type of extreme and particular scenarios that the Supreme Court is saying you can't find people morally at fault for murder in these situations. They can't formulate that intent. In my view, the cases here, these are cases where individuals should not be found criminally at fault. It's really not their fault. They didn't think this would happen, and I'm sure the killing of people dear to them, Mr. Sullivan's mother, Mr. Chan's father, that's going to be punishment enough for them for years and years to come. So I don't think that the case is exactly the way the media has portrayed it, and hopefully Parliament, instead of messing around with trying to make it illegal for YouTubers like myself to broadcast or to put us under the control of CRTC, they'll rework 33.1 so that it will be compliant with the Charter. This video is not legal advice. If you need legal advice, call a lawyer. You can call another lawyer or myself. My phone number and website are listed below. If there's any topics you'd like to see me cover, please send an email to the email address listed below or leave a comment in the comment section. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.